Would you please state your name for the court?
My name is Justin Gordon.
And where are you currently employed?
I'm employed in the Open Records Division of the Texas Attorney General's Office.
And what is your position there?
I'm the Open Records Division Chief.
How long have you been the chief of the Open Records Division?
I began in 2015 at the beginning of General Paxton's term.
Excuse me, I think you're going to have to speak louder and a little closer, okay?
I began in 2015, in January of 2015.
What does the Open Records Division do?
Our division handles a number of responsibilities regarding the Texas Public Information Act. That includes enforcement and review of public information decision requests. We also provide training for governmental bodies on the Public Information Act.
Okay, I'm going to ask you just to slow down a little bit while you're talking, okay, to help the court reporter out. Can you tell us how many public information ruling requests your division handles a year?
Last year we did over 40,000. In the previous fiscal year we did just under 40,000.
And does your division maintain a record for each ruling request?
Yes, we maintain both an internal record of our ruling requests. We also post all of our letter rulings on our website after they are issued.
Do you recall a request for ruling from the Texas State Securities Board in the fall of 2019 for some records related to Nate Paul?
Yes.
Do you recall if any records were released as a result of that ruling request?
I do not believe any records were released in response to that ruling request.
Do you recall if there was a request for reconsideration of that ruling?
Yes, there was.
How frequently does the Open Records Division receive requests for reconsideration or complaints about a ruling?
That's very common. I don't have an exact number to provide you, but that's something that we see certainly on a monthly basis, if not weekly.
Were you also involved in deciding a request for ruling from DPS, the Department of Public Safety, in the spring of 2020, which we're going to call the big request for ease of reference? Do you recall that one?
Yes, I do.
Was that also related to Nate Paul, if you recall?
It was.
At some point, as one of your duties, as part of your employment, did you make a summary of that file?
I did.
Your Honor, if I may approach the witness.
Yes, you may.
I'm going to approach with what is marked as AG.
Hold on one second. Yes, Senator Whitmire? Okay. Allison, you're going to have to speak louder as well.
Even louder, okay.
That'll do it. That'll do it.
I'm going to approach with what has been marked as AG 205, and it has been pre-admitted.
Okay. Members, do you need for us to review with the court reporter what has already been said? You're okay? Everyone's okay? You do? Okay. Okay, so let's go back to where you began the question on DPS, Senator West. Securities. Okay, let's start over.
No problem. Do you recall receiving a request for ruling from the Texas State Securities Board in fall of 2019 for some records related to Nate Paul?
Yes.
Do you recall if any records were released as a result of ORD's ruling?
No, I do not believe any records were released in that ruling.
Do you recall if there was a request for reconsideration of that ruling?
Yes, there was a request for reconsideration.
How frequently does ORD receive requests for reconsideration or complaints about a ruling?
That's very frequent. I don't have an exact number to provide to you, but it's something that we see, if not on a weekly basis, then certainly monthly, several times a month we receive reconsiderations.
Do you also recall being involved with a request from DPS in the spring of 2020 related to Nate Paul?
Yes.
Now, we've been calling that the big request to help distinguish them. Will you understand what I'm saying if I call it the big request?
Yes.
Thank you. And at one point, as part of your employment, did you create a summary of this file?
Yes.
Your Honor, I'm going to approach the witness with what has already been admitted as AG 205. Mr. Gordon, do you recognize this document?
I do.
Is it a fair and accurate depiction of the summary that you created for this file?
Yes, it is the summary I provided for the file.
Well, let's talk about it. Let's walk through it together, okay?
Okay.
First, how would you describe this particular request, the big request?
It started off as what I would have characterized as a relatively routine request from the Department of Public Safety. Department of Public Safety routinely briefs our office on law enforcement matters. They, again, very commonly submit rulings to our office. However, as the ruling was being reviewed, it took a turn procedurally, and then there was a number of procedural irregularities that occurred with the file that made it unique.
And Eric, if you could please pull up AG Exhibit 205 and highlight the first paragraph, please. And Mr. Gordon, I think it's consistent with what you just said that there were procedural issues that made this file unique. Is that correct?
That's correct.
Okay, and when was the request received by your office?
On March 13th.
Okay, and at this point, this is when you're talking about it was very routine?
Correct.
Do you recall what exception DPS was asserting?
They sought to withhold the information under the law enforcement exception. That's Government Code Section 552.108.
Is that, there are generally two types of exceptions under the PIA, is that right?
That's correct. There are two, we characterize them as two separate types of exceptions. There's an exception for confidentiality provisions that we would also call mandatory exceptions. And there's a type of exception that is just a normal exception to disclosure that we would call a permissive exception to disclosure.
And which type is the law enforcement exception?
Section 552.108 is a permissive exception. The governmental body has the option to raise it or not to raise it.
What happens if they do not raise it?
Nothing happens if they do not raise it. We won't address it if they do not raise it.
So if they don't raise it and you don't address it, what's the end result as it relates to the request? Are those records released or are they withheld under the law enforcement exception?
Oh, they would be released. They would not be withheld under the law enforcement exception.
So let's talk about some of the procedural irregularities in this file. I'm now in the second paragraph, Eric, if you could blow that up for the senators. Where did this file first start to take a turn towards the unique?
Where you have it highlighted, I described that. Excuse me 1 second. I'm very sorry. I'm very understanding with 8 grandchildren and a lot of little ones, but we really can't have a distraction. I'm sorry. Might have to step out. I really apologize, but I don't want to distract the jurors. Very sorry for that.
May we continue? Thank you. I believe you were about to point out to us where the procedural issues started to arise in this file.
Sure. So we have a statutory 45-day deadline by which we have to issue all of our rulings. That's from the government code. And as we were approaching that deadline, the DPS submitted a follow-up correspondence to our office explaining that the requested information may implicate the interests of the FBI. And at that time, they also submitted additional records. So in the initial submission, they only submitted a representative sample, which they are permitted to do. In fact, the PIA requires them to do that if the records are voluminous, and they had done that in the initial submission. However, when they submitted the subsequent submission, they submitted additional documents, not the same representative sample that they had submitted earlier. And the new documents were substantially different than the documents that had been originally submitted and were of a different character. So they
and I'm going to stop you. I think that's a great spot. And just to summarize, so essentially the original representative sample that DPS sent in did not match with the sample that they later sent to your office in May of 2020, is that right?
That's correct.
And they sent that second sample at the time that they were notifying the FBI that they might have an interest in the file, in the information being sought by the request?
That's correct.
Is that considered a procedural violation under the Public Information Act?
Yes, governmental bodies are required to submit all of the records that they want a ruling on or a proper representative sample by the 15th business day after receiving the request, which had been substantially before this time period.
So this sample was also late, is that correct?
That's right. That's correct.
What is the consequence for a procedural violation of this nature?
Under the Public Information Act, failure to comply with the procedural requirements in requesting decision from our office results in a presumption that the information is released unless the exception that they're raising constitutes a compelling exception. And our office has concluded that Section 552.108 does not constitute a compelling reason. That's a fancy way of saying that they waive that exception, and they would waive it for the information that they had the procedural violation on.
And that would be all of the information that they provided as the second sample in May of 2020?
Correct. Anything in that representative sample, the second set of documents that was not in the first set.
And is it your understanding that that second set of documents had also been provided to the FBI?
Oh, I'm not sure if they provided that second set of documents to the FBI. I don't remember that.
So this late, was the notice to the FBI also late?
Yes. Governmental bodies, there are procedural requirements and there are also due process requirements in the Public Information Act. And because of those deadlines, there are certain notice requirements. So the only notice requirement in the Act that applies to third parties is in Section 552.305. That section requires governmental bodies to notify third parties if their privacy or proprietary interests are at issue, and that notice is supposed to come within 10 days of receiving the request. Otherwise, there's also the due process element of that notice needs to be made in time for those comments to be received by our office before, in time for us to be aware of them, and also in time for the requester to receive notice.
And in this instance, was the notice given close in time to your statutory deadline to issue a ruling?
Yes, we received it just a couple of weeks before our 10-day deadline or our 45-day deadline.
The second sample of the second set of documents that you were provided by DPS, how were those provided to you? Hard copies on a CD, do you recall?
I don't recall if they were a CD or if they were a hard copy.
Okay, so you sent the notice went out to the FBI and you received a copy of it. What happens next?
So at that point, we were kind of up against it with respect to the timelines. You've got the highlights here with respect to the to kind of what was going on in this file. We had also been notified by the requester in this file that he had filed a lawsuit against DPS in this case, which added a whole nother layer of complexity to it. Because the late notice, because the notice was received so close up against our 45-day deadline, we didn't feel like the third party who was notified, FBI, would have had time to submit comments to our office in time, and so while we were waiting for those comments so that we could receive them and review them from the FBI, we took a 10-day extension on it, and again gave ourselves a 10-day extension, which is permitted under the PIA.
All right, I'm going to ask you just to slow down a little bit, okay? You're doing great. So you extend it for 10 more days. Does the FBI eventually provide your office with comments?
Yes.
And do you know if the FBI also provided the requester with a copy of those comments?
At the time, when we identified the documents, we actually only found the comments because the requester let us know that he had received comments, and so then we went and tracked them down. This is at the beginning of COVID, so our mail intake was kind of thrown off. So when the requester notified that we had received comments, we went and tracked those down. To add another procedural complication to it, at that time the requester notified us that his copy of the comments had been completely redacted. Our copy did not have any redactions on it. It just had a reference that at the end that the version that had been provided to the requester was redacted.
In your honor, if I may approach with what's been marked as House Managers 46 but has not been admitted into evidence yet.
You may approach the witness.
Mr. Gordon, do you recognize the document that I placed in front of you?
I do.
What is it?
This appears to be a copy of our internal ruling file pertaining to the DPS file that we've been discussing.
And does it appear to be a complete and accurate copy of the file?
I'm sorry, I'm just double checking.
Take your time.
Yes, it does.
I appreciate your thoroughness. At this time, we'd move to admit House Managers 46.
Any objection?
Mr. President, no objection to the admission. However, in this document, it contains a copy of the unredacted FBI brief, which not only contains personal identifying information, but a number of sensitive information of the types of operations plans and other sensitive law enforcement information, which Nate Paul had been trying to get for a while. If it comes in, we just ask that it be redacted because that information has not been publicly made available.
And Your Honor, we'll get to that on the next request, but I will represent to this court that that is not the case. As has been discussed by other witnesses, this brief was in fact released publicly.
Okay, so they did not object, and I'll let her go along with her line of questioning, and we'll get back to that issue, but thank you for bringing it up. Go ahead.
Thank you. Eric, if you could pull up towards the back of that exhibit 46, the Bates number at the bottom is 8803.
Mr. President, I do have to, I'm sorry, before this is shown to the jury, there is personal identifying information that
sir,
has not, may I finish?
Stop, not talking over each other.
That has not been released publicly. It may have been released to Nate Paul at General Paxton's direction. However, it has not been made public to the world at large. Okay. There's very sensitive law enforcement operation plans, details about search warrants, how investigations are done, and also specific names of individuals that are identified and involved.
Come on up to the bench. Please come up to the bench.
Yes, sir.
Okay, so Deandra, talk about this.
Well, I think the prosecution is absolutely correct, and the defense should have offered a redacted version of this. I see Judge Myers leaning over listening because she's thinking the same thing I am. It's like, what are y'all doing and what's in this document? Just because you've got the correct witness there to support a document coming in doesn't mean everything in it's admissible or should be admissible. So it'll be interesting to see what the ruling is here. I'm sure whatever the ruling is going to come from Judge Myers.
I mean, it'll be Patrick saying it, but you think that it'll be...
Yeah, because he has no clue, and she's listening pretty intently on this video. So
I think it will be Dan Patrick, whether he has a clue or not. What the defense is arguing is, once again, the ruling power of the Attorney General that he gave this to somebody, so it must be public, whether it should have been public or not.
Well, and therein lies
you can hear some pretty heated
issue.
conversation up there a little bit. I mean, you can't exactly hear what's being said, but it sounds heated. Deandra, while we're kind of waiting on them to rule on this, or waiting for Dan Patrick to rule, you think that Dan Patrick understands hearsay?
No. Some of his rulings, like I was laughing yesterday because it seemed like Busby kept saying, "That's not how this works. That's not how any of this works." It's like the TV commercial where they say that. I kept laughing because that's not an objection. That's not even a... But he had figured out that if he just yells really loudly and says that's not how this works, he was winning a lot of the objections.
Was Busby correct? Is that how this works?
No, I mean but
that's how winning your case works.
That's how making objections in front of a judge who doesn't know what they're doing works. You know, I've done it before. I'm guilty. I've gotten up and said, because I see if I just yell or say certain words, the judge will rule for me because they don't really know what the answer is.
He was trying to control Dan Patrick, wasn't he?
Yes, absolutely.
And how successful was he?
It was very successful. And it was, but when Aaron was up though, she had citations and hearsay exceptions, and she was citing the code and everything. And then
and there was times when he was ruling against her, and she was right?
She was right, yes. And there were some times he let things in that I think should have been sustained. So he's been all over the place. But I've practiced in front of non-judge lawyers or non-lawyer judges before, and this is what you get.
This is a key ruling, isn't it? Because this is one of the key parts of the trial of whether all this grand jury testimony and all the data and the law enforcement identities and everything else should have been given to Nate Paul.
And if you have any experience trying to get open records and going through this whole Attorney General process, I mean, they don't just release this stuff.
Love from the AG's office?
No. And I know you haven't either.
No. I promise you, they have never said, well, that law enforcement agency busted that line on that law enforcement exception. King's X, you get it. No, what they'll do is they will bend over backwards if that law enforcement exception can be claimed. You're not getting it.
Yes.
The end. Because even if they file it late, you're still not getting it. And I'd like to know when he says the representative sample was one thing, but they filed substantially different documents. What do you mean? What does that mean?
One different page, or
what's substantially different?
Yeah, notice that hasn't been asked or answered yet. I'll be interested to see if
to me that is an obvious question to ask.
What was the difference?
On cross.
And again, arguing the defense's position here, the defense is going to say that the Attorney General obviously had the authority to release this. It's obviously public record, and this is an important part of the case because we're showing that the DPS was part of the vast conspiracy to get rid of Ken Paxton. So, I mean, they've made the DPS into their boogeyman, the federal government, the boogeyman, the FBI, this whole investigation is all rigged to get rid of Ken Paxton.
Deandra, when you run a conspiracy, do you usually involve a lot of people?
Yes. Well, no, you have a core group. I mean, there may be a lot of people in drug conspiracies. There will be people that know a little tiny piece of the conspiracy, because they indict 30 people.
Right, but let's say a political
but on this,
conspiracy.
No, it would be a small
cabal.
Small group.
And the reason for that is because the more people you involve, the more people might talk. That's why, Tanya, we're sitting right here a few blocks from Dealey Plaza. Every time someone says there must have been a conspiracy in 1963, you say, well, if there was a conspiracy, somebody would have talked by now.
Exactly. And
very true.
And I mean, in this particular conspiracy, the Nate Paul conspiracy, right? The idea that, so you're going to have, we haven't said this in a couple of days, so I feel like I have to say it again. We're going to have a federal magistrate judge.
Don't forget the clerk.
The clerk who's dead.
Yes, the dead clerk.
A bankruptcy judge, U.S. attorneys, FBI agents, DPS, State Securities Board, agents with the State Securities Board, a member of the State Securities Board. All these people got together and conspired against Nate Paul.
Whoever changed the letterhead, it goes all the way down to
letterhead gate.
Yes, exactly.
I mean, everybody.
That's
just a ridiculous one.
No, it's completely ridiculous. But that's that's their theory, is that there was this big, well, it was Nate Paul's theory.
Well, we actually have two conspiracies. We have the conspiracy to get Nate Paul, right?
Which is what Ken Paxton was investigating.
Right,
Yes.
and then we have the conspiracy, the alleged conspiracy, to get Ken Paxton.
Yes,
And,
which
but-
took
which
all these
involved
people,
all these people.
all these law enforcement agencies.
And all these political factions.
Right, and that his hand-picked lieutenants in his office, people he had hired and put into place, they all got together, I guess at Johnny Sutton's direction. Is that what we're?
No,
Bush, I
whether
mean-
it was at Polvo's or at Galaxy Cafe.
Well, if it was at Starbucks, make sure you got your ride home.
That's right.
That's all
Oh
I've
my
got
God.
to say.
Well, while we're sitting here waiting, you watched Brandon Kamek's testimony.
That was
Talk to me
unbelievable.
about what you thought about that.
Well, he was a little patsy, which is sad for him, but I think the whole story about them going to the Starbucks, won't even let him in the building to have a meeting in Ken's office. Oh, we'll meet you at the Starbucks. We'll take you to the Starbucks. You can't actually come in the building. And then we're going to tell you, not only are you done, your contract's void, we're not paying you, tough. And then we're just going to drive away and leave
Well, they
you
did
there.
give him a ride ultimately.
Well, because
They
they said, hey, are you just going to leave me or do I have to Uber back to my car?
They wouldn't pay him what they owed him, then they ditched him at the Starbucks.
That's just unbelievable.
This is a bad romance.
It was not a good situation
Well,
for
and I
Brandon.
keep going back to if everything is on the up and up with this contract, right? If everything
Yes.
is good to go with this contract, why don't you pay him? Why? To me, you say we paid the guy. We paid the guy for the work he did. So nobody has explained and maybe they will explain why why Brandon Kamek doesn't get paid.
And you've got a giant trust fund that you can just move $121,000 out of when you need to.
Well, that's Ken Paxton's personal funds.
Right, but they refuse to pay Brandon Kamek, and it's come back to bite them.
If you were a prosecutor,
Forgot.
right?
Yes.
Most lawyers I know,
Yes.
at one point in
In
their
Dallas.
lives in Dallas, were prosecutors at some point or
under
another.
John Vance. So a long time ago. I'm dating
That's okay.
myself
Well,
big time.
I could start dating myself too. When I started quoting from A Few Good Men yesterday, I knew that I was dating myself. But if you're going to go out and you're going to pick somebody because you think there's a grand conspiracy against Nate Paul, do you pick Brandon Kamek as the guy that's going to be the guy to investigate this?
Well, if you want someone who's not going to ask any questions, you absolutely pick Brandon Kamek. He's the perfect choice. But if you want someone to actually do a real investigation, it was the other guy, the guy that used to be
Joe
out
Brown.
in Grayson County, Joe Brown. He would have actually he was reluctant because the whole thing sounded,
Cuckoo for
that's
Cocoa
why he didn't
Puffs.
get the job, is because he was like, okay, well, I'm willing to look at this and write a report. Whereas Brandon was like, oh, wow, this sounds
convincing.
This sounds very convincing. You're showing me some metadata. And so this sounds really bad.
Can you get
so
Nate
that's
Paul's
the guy that gets the
attorney to
job.
come out with me and serve these subpoenas?
Which was that. I'm sorry.
That's
I'm
not
sorry,
regular-
viewers.
Are you
If
sure that's not regularly done?
If
Are
you
sure?
think that happens, I am sad to burst your bubble. That was one of the biggest things I've heard. That was just no way did that happen.
Well, and then the idea that you have Nate Paul's attorney, not only that, which is cuckoo for Cocoa Puffs, but you also have Nate Paul's attorney providing the list of who you need to go subpoena, and on that list is all these law enforcement people, these federal magistrates, these banks, and also opposing counsel in civil actions involving Nate Paul.
Well, so once again, Kamek was the perfect guy because he wasn't experienced enough to know that something was very wrong. Something was very wrong, and that the other Joe Brown would not have done that. He would have said, "No, wait a minute. I'm willing to look into this, but I'm not issuing subpoenas to some federal judges and magistrates over this."
And Brandon Kamek doesn't even seem to, based on his own testimony, seem to have been aware of who he was really subpoenaing, who these people
Yes.
were. He seemed to be taking at face value.
He had a list of names.
Yeah, give me a list of names and let me send them out into the world. I have never heard of such a thing.
He didn't ask any questions because he he didn't see what was happening. He didn't ask any questions because he was young and inexperienced, and he was the perfect guy for the job.
Obviously, you both have bought into the vast rhino conspiracy.
Well, I'm telling you what, if you're going to be a rhino, it's not going to be any of those people I've seen testify. Those are some of the most conservative people that I've seen, and those are true believers that I've seen testify, and they've not been rhinos. If you're going after them, I really don't think well, the senators are obviously the jury, so it's effective possibly in front of them, but in a real criminal trial, you need a better story, a better theme from the defense. I think the theme could have been there was just a lot of mistaken information. Like the guy misunderstood, we're going to check with Nate Paul thing. Like it was just all a misunderstanding. You could have cleared up misunderstandings as opposed to the vast, what do you call it, the vast right-wing conspiracy?
Well, I guess this is a vast rhino conspiracy, right? I mean, run by Johnny Sutton and George P. Bush, I guess? I mean,
yeah, we've got Dick Weakley, Johnny Sutton, the FBI, the DPS, Dade Phelan, the Bushes, George P., his family, and the Ashcroft Law Firm, and I think probably the school crossing guard at Ann Richards Elementary School in Austin.
You could have gone.
Let's take a listen.
Members, take your seats. So we're going to proceed slowly, carefully. You may proceed.
Thank you. Mr. Gordon, as a preliminary matter, if a document is released after a ruling request or a ruling decision, would that be released to a subsequent requester for that same information?
Objection calls for speculation.
Overruled.
Yes, there's a specific section that directly addresses that. Section 552.007 of the Government Code prohibits the governmental bodies from selectively releasing information and provides that if information has been released to one requester, then it would be released to a subsequent requester unless there's a special right of access that applied to the initial requester.
Okay.
Sorry.
All right. Mr. Gordon, repeat your answer. Slow down.
Yes, sir. Yes. There is a specific section of the Public Information Act that addresses that. It is section 552.007. It provides that if information is released to one requester, then it would be released to a subsequent requester. It prohibits the selective release of information to one requester and not to another. So if information has been released by a governmental body, then it would be released to subsequent requesters unless there is a special right of access that only applied to the initial requester. For example, if I ask for my driver's license number and receive it, you wouldn't release my driver's license number to the next person because I have a right of access to that.
Thank you for that explanation. Eric, could you please pull up within House Managers 46 at Bates 8803, which is page 77 within that PDF. Mr. Gordon, can you see that on your screen?
Yes, I can.
Does this appear to be a fair and accurate picture of the redacted brief the FBI provided to Mr. Larson?
That's correct.
And Eric, if you could scroll to the next page, so to 78, go down. Is this showing an entirely redacted page?
Yes.
And does that continue through the majority of this brief?
Yes.
Is this unusual?
Yes.
Can you explain why?
Under the Government Code, if a third party submits comments to our office objecting to the release of information, they're required to notify the requester and provide the requester with a copy of those comments. They are permitted to redact the comments, but only to the extent that it reveals the information that is requested. In this case, they've redacted the entirety of the brief, including all of the substantive arguments.
And why does that matter?
That matters because the requester was not put on notice about what arguments the governmental body was making and would have been unable to respond to them to our office in order to refute any statements that were made or directly address the statements that were provided by the briefing third party.
Is this another procedural violation of the PIA?
Yes.
So far we've talked about at least 3 procedural violations or irregularities with this file.
Objection,
Yes.
leading.
Restate your question. Sustain.
Can you estimate for us how many procedural irregularities we have discussed related to this file so far?
There was the failure to submit the representative sample, or they submitted the documents late. Mm-hmm. The representative sample that they submitted the second time was not indicated that the first representative sample was not actually representative. They did not notify the third party in a timely fashion. And then when the third party briefed us, they substantially redacted their briefing to us. Or I'm sorry, they substantially redacted the copy of the briefing that was provided to the requester.
Are you able to tell us how frequently you work on a file that has 4 different procedural irregularities?
We see a lot of procedural irregularities. These are pretty unique, though, in the way that they came in. Ordinarily, what we see are missed deadlines. So it would be pretty rare that we see 4 completely different procedural violations like this.
And again, what can be the consequence of a procedural irregularity of the nature you've been discussing?
If a governmental body fails to comply with the procedural requirements of the Act, then they would waive their discretionary exceptions.
Meaning that any documents that fell within a discretionary exception would be released?
Objection, leading.
Sustain. Rephrase your question.
So what's the consequence of that, of the permissive exceptions being waived?
If a permissive exception is waived, then we would not apply it or review it in the context of those documents. And if that's the only exception that's addressed, then those documents would be released.
And in this particular file, the DPS file in front of you, was the only exception raised the law enforcement exception?
That's correct.
And it is a permissive exception?
That's correct. They did not raise any confidentiality provisions. They only raised the law enforcement exception.
Do you recall meeting with the Attorney General about this file?
Yes.
And I don't want you to go into what anyone said at that meeting, okay? But could you please tell us what topics were discussed?
We discussed this topic, this DPS file.
Did you discuss options for how to proceed?
Yes.
And what were those options?
The primary options were to release the information, to conclude that there had been a procedural violation and a failure to establish that the information was accepted from disclosure. And then the second exception, which was the primary option, was the closed letter that we ended up issuing.
Did you agree with issuing the closed letter?
Yes.
Why?
It was correct. The procedural background of the request put the requester at a significant disadvantage, and allowing the procedural actions that were taken would have really been a detriment to that requester. There was already a pending lawsuit, and courts will give our letter rulings great weight, and rubber stamping the actions in this procedural context would have or could have, I don't know what the court would have done with our ruling, but it could have tilted the scale in favor of a governmental body who had failed to comply with the procedural requirements.
And I want to make sure I understood your testimony a moment ago. You considered releasing all of the information. What do you call that within ORD?
Pouring out.
And would that have been supportable under the law, in your opinion?
It would have been pushing it. I agree with the closed letter. I feel like releasing it all would have been pushing it.
To your knowledge, had ORD issued closed letters of this nature in the past?
Yes.
Eric, I'm going to ask you to pull up the closed letter, which is within House Managers 46 at page 2, and please take it off the screen before finding the new page and placing it there.
Counsel, what was the Bates number that you directed him to, please?
It's page 2 of the PDF, which is in front of you.
That OAG 8728?
I don't have it in front of me, but it's the closed letter. Mr. Gordon, does this appear to be a complete and accurate copy of the closed letter?
Yes, it does.
And in that letter, you reference a prior ORD decision, right?
That's correct.
Why? Why did you reference that prior ORD decision?
Well, there were a lot of reasons. The primary reason is that what this open records decision specifies is that if a lawsuit is filed after a ruling request is made, I'm sorry, let me take it back and maybe simplify it. Under the Public Information Act, a requester can sue a governmental body if they believe they're improperly withholding documents. What this open records decision provides is that if a requester files a lawsuit after a governmental body has issued or has requested a decision from our office, then our office should still go on and issue a ruling. Prior to this decision, we routinely closed files and did not issue determinations where the issue that come before us in the decision was in court. So we would demur and close that letter and let the court decide.
And in your opinion, how did this DPS file differ from the closed letter that you issued in this case? How did that differ or was distinguished from that ORD decision?
It was all of the procedural irregularities, especially the redacted FBI brief. That was the primary issue that prevented us from ruling in accordance with due process. It was the heavily redacted FBI brief.
And why did that cause you so much heartburn?
Again, our rulings are given weight or great weight, quote unquote, by the courts. And in the face of those procedural irregularities, giving a rubber stamp of approval to them could have tilted the scales in that court, even despite the procedures being handled incorrectly.
Could it also set bad precedent?
Objection leading.
I'm asking his opinion, Your Honor. It's a yes or no. He can say what he'd like.
Overruled.
I'm sorry, I didn't understand. I didn't hear the question.
Sure. Could it also set bad precedent in PIA requests coming into your office?
Objection, Your Honor. The relevance of this personal witness's opinion is not relevant to any issue in this proceeding. And what he considers a good or bad precedent is purely subjective and not at issue in this case.
Your
Overruled.
Honor, thank you. You can answer the question.
I wouldn't characterize it as a precedent. So many of our rulings are fact specific. What I do think it could have resulted in, because DPS and FBI routinely brief our office, it could have again been seen as condoning that type of heavy redaction, which then could have led to that type of action being taken in future requests and for future requesters. So I wouldn't have characterized it as a precedent, but it could have indicated that we thought that was okay, and then they would, because they do it routinely, they request decisions from us routinely, they could have seen that as oh well, now we've got the stamp of approval to do this, and now we'll keep doing it.
And now, while all of this is going on, were you made aware of a request from Mr. Larson for a copy of the FBI brief?
Yes.
How were you made aware of that?
That came in as a Public Information Act request. The Public Information Act request was forwarded to my division for handling. And when I say handling, I mean we collected the documents. So we collected the unredacted brief in processing that Public Information Act request, and we provided it to our Public Information Office.
As to the DPS ruling itself, did that closed letter result in the release of any documents?
It did not.
Okay, so this request from Mr. Larson comes in for a copy of the brief. Do you know what happened after that was received?
I know what happened after the fact. Because it involved open records decision documents, our division does not rule on decision requests for our own documents, so it was handled by another division. But through the process of this whole circumstance, I did become aware of what issued or what happened with that public information request.
And your division maintains those files even if it doesn't necessarily make the decision on the request, correct?
That's correct. Because the FBI submitted the brief to our office, we were the ones who maintained that as part of our work file.
Have you reviewed the ORD file for the FBI brief request before?
So just to clarify, our office or my division does not have a file on that public information request. We have the file that's here before me as this PDF, and yes, I have reviewed that, but I have not seen the opinions file or the public information office file involving that ruling request for that brief.
Now, in the file in front of you, there is a copy of the unredacted FBI brief, correct?
That's correct.
Would you take a look at it, please?
Okay, I'm looking at page.
And what I want you to look for, you're the chief of ORD. I want you to set aside law enforcement exception for a moment. I want you to look at that brief and let me know if you think there are any mandatory exceptions to public disclosure that are flagged within that brief.
Not to nitpick, but there is Mr. Larson's email address is at the end of the brief, but he was the requester. So no, but other than that, I don't see any confidential information on the face of the document.
Thank you. And just one more thing on, forgive me. Your Honor, if I may approach with what's been marked as AG 34.
You may.
Mr. Gordon, do you recognize the document I placed in front of you?
I do.
And what is it?
This would appear to be the internal file for the opinions ruling request that we've been discussing that was Mr. Larson's request for the unredacted FBI brief.
Does OAG receive requests for copies of PIA briefing on other occasions?
Yes.
Does that occur can you tell us with any sort of frequency how often you receive that type of request for briefing?
If I had to guess, I'd say it would be once a month, probably less than once a month it's not very common. It's not a weekly occurrence.
And were you familiar with Joe Larson?
Yes.
How?
I've worked with Joe Larson for a long time. He is a well-known open government lawyer. He's also involved with the Freedom of Information Foundation, which our office has partnered with in the past to perform trainings. He's routinely sought after to provide input on Public Information Act requests. I've also observed a number of cases that he's handled because he ends up often handling important Public Information Act cases. So I've known Mr. Larson for a long time.
Based on your knowledge of Mr. Larson and working with him, was it surprising or unusual for him to submit a request for a copy of that redacted brief?
No, I wasn't surprised at all that Mr. Larson would ask for that.
And you started to walk us through what OAG does when it receives a request for documents that OAG itself holds. I just want to make sure that's clear for the jurors, okay? So let's walk through it. So what's the first step OAG would do when it receives a request for records that it itself holds?
That would be received and handled by the Attorney General's Public Information Office.
Objection, Your Honor. I apologize to the witness, but at this point, it's clear from the witness's own testimony that once this request that's about to be discussed was made, it went to a different division, not his, that he does not oversee, and he's previously testified that he was not involved. So any information that he has about specifically how it was handled or by whom would be hearsay or speculation.
Your Honor, right now I'm asking him to walk through the general process of how this is handled, which is something that as the chief of ORD, he is intimately familiar with.
The witness can answer. Overruled.
When a request comes into our Public Information Office, the Public Information Officer will identify the divisions that they believe maintain documents, and they will notify those divisions. Those divisions then collect the information. Generally, we collect the information unless there's some issue with the request, like we don't understand it or it would require a cost estimate. Those divisions, my division in that case, will respond back that we maintain documents, and then we'll follow that up by providing those documents. If a decision is required, then the Public Information Officer will prepare that decision, and they will send it to our division. As soon as we see that we've received a request from the Attorney General's office, it gets segregated out, and at this time, it would have been forwarded to the Opinions Division.
So ORD is not deciding decisions on documents held by ORD, is that right?
That's correct.
Action leading.
Sustained. You can re-ask the question.
I think the point's been made, Your Honor. I'm gonna move to admit AG 34. It is an internal business record of OAG. It was actually given to us pursuant to a business affidavit that has been on record for more than 14 days.
And Your
Any
Honor,
objection?
as we discussed at the bench, the issue is not the business records affidavit. It is protecting the sensitive information of law enforcement, how they conduct their investigations, and specifically the individuals involved. An exact identical copy of the same brief we just talked to you about at the bench is also contained in this document. And so I have no objections as long as she's willing to protect law enforcement and the integrity of their investigations and redact that sensitive information. With those redactions, no objection.
And Your Honor, the chief of ORD has now looked at this brief and told you that there were no mandatory exceptions and no confidential information within that brief. Right. He's also testified that once documents are given to one requester, they are given to any subsequent requester. They are considered public. And so I do believe that he is one more than very highly qualified to speak to this file, and that there are no confidentiality concerns raised within it based on this witness's testimony.
Brief response, Your Honor?
Yes.
Everything my colleague said misses the point. All I'm trying to do is make sure that the sensitive law enforcement information, which is in front of you, the identities of the individuals involved in the investigation, how they conducted the investigation, their sensitive operations plans, their sealed search warrant affidavits, and the details contained within, how they communicate with each other, who was on those communications, and when they were sent, all of that information I just would ask would be redacted. Otherwise,
and Your Honor, very quickly.
Stop. Don't talk over each other. Court reporters have a tough job as it is. Come up for a moment again.
Well, you know, Deandra and Bud, I have filed lots of open records requests in my life. And I feel like when this trial is over, I want a transcript of this guy's testimony because I plan to use it the next time.
They deny.
Yes, absolutely. The next time a law enforcement agency busts a deadline and claims the law enforcement exception, and then they still try to withhold it, I'm going to say, hey, this is what y'all do. You did this for Nate Paul. I'd like the same treatment. Well,
this is one of the key points. The House wants to say they made special effort and went to a special extreme to help Nate Paul. The defense wants to say, we're the Attorney General and we can do whatever we want.
Well,
I think that it's also hard because they're talking about things we can't see. It's been one of the things I've noticed this whole time. You know, normally in a trial, exhibits are produced and you can see them, and we can't see any of this stuff. So it's even hard to understand what they're actually talking about. But I agree 100%. Usually the AG's office, it's law enforcement exception all
whether
day long.
Deadlines are busted or not. And I have had them, and I can't remember the exact language, but I have had situations where filed the request, law enforcement agency, oftentimes the Dallas Police Department busts a deadline, still files and says, you know, and I'm paraphrasing here, we still claim in the law enforcement exception, la 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 la, and I still don't get it.
Yeah, rubber stamped. Rubber stamp letter. We've gotten them too, where we've requested stuff from police agencies. Police agency goes way past the deadline. AG's office still turns
are you going to
down.
be citing this in your
briefs?
I
think we're going to call it the Nate Paul exception now, I guess.
Yeah, I mean, I want the Nate Paul exception too. I want that kind of love from the Attorney General's office, and I plan to ask for it. And I guarantee you that every reporter out there in the state is going to be doing the same thing. So the AG, they have just opened up a big old can of worms.
Well, it sounds like you just need to email Justin Gordon
and
say, Justin, hey, Justin,
I want the Nate Paul exception.
I want the Nate Paul exception.
I want that love from you.
Because they're late. There's some, what's he call them? Procedural irregularities. So hand it over.
Yeah, first sample turned in late. The representative sample they initially turned in was substantially different than what they turned in
and
later.
No one has explained what that means.
Yeah, what does that mean?
This reflects the antagonistic role the AG's office took toward other law enforcement agencies, toward the court, toward the DPS. I mean, the AG set itself up as the sole arbiter of what was constitutional and unconstitutional, regardless of precedent or other law.
Well, I'm really looking forward to the cross. I want to see what she asks old Justin Gordon about how many other times he's done this. Those are the kinds of questions you're going to want to ask. Like, how many other people where there were procedural irregularities did you go ahead and take these actions for?
I would love to hear that. I want to hear that.
And also, what specifically was different about what you got the first time and what you got the second time? What was the substantial difference?
Well, they're using some buzzwords here.
Yeah,
procedural irregularities.
Yeah, what does that mean exactly?
And substantially different. Well, you know, is it really all that different? I mean, because they haven't, like you said, they haven't explained what they mean, and I guess we also don't understand. We don't really know like how this time. You know, the prosecution only has a little over 2 hours. You know, how is that going to hamper their ability to cross? Or do you need much time to cross this guy?
Probably don't. I mean, you should have your list of questions and go bam, bam, bam. I don't know who this young lady is who's acting on the behalf of
the defense.
Somebody sent me that.
No, the
Hold on,
state.
I'm gonna go look up the
Or
name.
the AG's office.
Well, Allison Collins, is that?
Oh yeah, Allison Collins.
Allison Collins is the defense attorney, and she. And it's interesting that she is sticking to this argument that because they gave somebody the document, they have to give everybody the document. That's state law, but you know, it would seem like at least out of courtesy, they would have some redacted version to give in public in court, just out of. She is sticking to that totally, saying we get to give out everything we gave out.
I am telling you, they are opening up a can of worms here that they are not going to be able to put back in. Every reporter in this state, lawyers like Deandra Grant are going to be saying, and it will become the Nate Paul exception to the open records law.
Right,
on these issues, because and law enforcement entities better stop busting deadlines and better start because we're going to all say, well, they busted the deadline. Where's my records? Send them on to me. Oh, and and I'm going to start requesting these briefs. I like the briefs too. Oh, and if you bust the deadlines on that, I'd like the whole thing.
Right, non-redacted. Yes, unredacted.
Also, we'd like all the call records from those 4 cell phones that the Attorney General had, but I don't think we're going to get those.
Well, people say I should be happy. Actually, no, this is thrilling from an open records perspective.
Yes.
This is like, I'm kind of excited because this is like new ammunition from an open records perspective. As someone who files open records requests practically daily, kind of considers it a God-given right. This is kind of cool.
Well, you've actually interviewed me on issues before regarding elected officials in Dallas County where I've said, well, why don't we try to get this record? And you're like, well, they're going to claim the law enforcement exception. They're never going to give it to us. Never going to give it to us.
How many times have you gotten something? One time, when Ethan Couch in Lakeside, and I requested all the tickets that Lakeside had written in a given day, knowing that one of them was to Ethan Couch. And I was able to get all those tickets. That's the only time that I've been able to get anything at all that involved law enforcement.
Well, tickets have a presumption of being public. Now, where you would probably run into problems is like there's going to be some things on that ticket, like dates of birth, driver's license,
address,
address. Well, yeah,
maybe
address. I think you would get addresses, but there are definitely driver's license. If they don't really put social security numbers on stuff like that anymore, but there are definitely some things that are confidential by law. But one thing I want to talk about while we're kind of sitting here.
Yeah, we're talking inside baseball.
We are. Well, it's because those of us that file open records requests, this is actually really exciting stuff. Yeah.
They're coming back.
Oh, they're coming back.
Let's see. Well, is there a little discussion going on up there with Patrick?
Let me take a look at the live. I've got the Senate feed up as well, the direct feed, which is about a little bit behind ours because we're trying to make sure that we don't step on any of the testimony. Yeah.
For people who want to know, what we're talking about here is Article 3 of the Articles of Impeachment, disregard of official duty. Paxton misused his power in administering the state's public information laws by directing employees to act contrary to the law on an open records request, releasing public DPS documents, and also in another case.
Yeah.
The House only has to prove one article of impeachment for Ken Paxton to be removed from office. They are prosecuting him on 16 articles. They're asking the Senate to sustain any one of those 16 articles to remove him from office.
Okay, so we're back in session.
Members, we will take a break in a little bit, just a little bit. Everybody be seated, please. So as we have been going through this testimony, slowly continue.
Mr. Gordon, the file placed in front of you marked as AG 34. Is there any search warrant inside this file?
There is no search warrant inside this file.
Are there any emails between the FBI and DPS inside this file?
There are no emails between the FBI and DPS in this file.
Did you notice any victim information inside this file?
I did not.
And if the redacted FBI brief had been released to one requester, it would be released to other requesters?
That's correct.
And you've had a chance to look at this file now, correct?
Yes.
And at the back of it, you'll see that, well, let's walk through it. So I think you've testified that based on this file before you, does it appear that OAG sent a notice to the FBI about this request for their redacted version of a brief?
Yes, it does.
Did the FBI respond?
Yes, they did.
And I want you to take a close look at their response brief, and specifically the last page under the signature line. It's the last page of the file. Are you there?
Yes, that's page 6 of the draft.
Witness needs to stay close to the mic and speak up.
Does it indicate that the version sent to Mr. Larson was redacted?
Objection, Your Honor. The counsel is mischaracterizing the evidence and honestly misleading the witness. The document that she is...
You may answer the question.
On this brief, it does not say redacted after the CC list to Mr. Larson.
And this brief was filed by a Mr. McPhillips from the FBI, is that right?
That's correct.
And from the front of this brief, was it filed, and it's actually marked as received by Open Records on or about June 18th, 2020? Do you see that?
Yes.
And then I want you to look immediately in front of this brief is a copy of the redacted brief at issue. Do you see that?
I'm sorry, would you repeat the question?
Yeah, if you keep flipping forward in the file, the next thing you see is a copy of the blacked out brief that the FBI had filed first.
Oh, I believe that's, I don't see in this.
The Bates at the bottom of the page I'd like to direct you to is 49982.
49982. Oh, yes, okay. That's the last page of the redacted version?
It's the last page of the brief that the FBI filed in May of 2020, right?
That's correct. I'm sorry, I was looking for the version that was actually redacted. There's no redacted version.
I apologize. There is no redacted version in here. And when you look under the signature, first, who signed this brief from May 2020 for the FBI?
Matthew Phillips.
So the same Mr. McPhillips?
Yes.
And underneath his signature line, what does it indicate next to Mr. Larson's signature? I mean, next to Mr. Larson's name on the copy list?
Next to Mr. Larson's name on the copy list, it says it was redacted.
So the first brief was sent to Mr. Larson, redacted. Is that what it represents to you?
Yes.
And so the second brief, the June 2021, based on the documents before you, was that redacted when it was sent to Mr. Larson?
It does not indicate that it was redacted.
Does that indicate to you that the FBI provided a copy of this brief directly to Mr. Larson?
Objection leading.
Sustained, rephrase your question.
What does that indicate to you?
That indicates that they provided the same copy of this brief that they provided to DPS, not unredacted.
And I want you to take a look at this June 2020 brief and tell me how it compares to the May 2020 brief.
They look very similar. There is some different language certainly at the beginning, but they look very similar.
Other than the first paragraph, they are very similar?
Yes, that's correct.
So based on the documents in this file, does it appear that Mr. Larson that the FBI provided this information itself to Mr. Larson?
Yes.
And the very front of this file is the decision issued in this case. It starts with Bates 49954. Do you see that?
I do.
And you just looked at the FBI's June 2020 brief addressing whether or not that blacked out brief should be released to the public, right? You just looked at it?
I did.
Did it anywhere in there argue that their redacted brief should be withheld from public disclosure?
No, it looked like the arguments applied to the documents that were issued in the underlying DPS file.
And so when that happens, when the comments don't address the information being sought, what, in your experience in ORD, happens in a file like that?
In that case, we would not apply the exception to the documents that are submitted. We ordinarily, because this opinion was done by opinions, they use slightly different language than us, but we've got boilerplate for that type of circumstance. Either that the entity that submitted the arguments is arguing against the release of information that was not submitted to our office, or that the arguments that they've submitted don't apply to the information that is at issue. Because we have a presumption of openness, there has to be an exception to disclosure in order to withhold the information. And if it's a discretionary exception, it wouldn't be applied to information that they don't seek to withhold. If it's a discretionary exception, they have to seek to withhold it in order for the exception to be applied to it.
And the FBI, so the FBI just didn't address their redacted brief at all, based on this file, is that right?
That's right.
Which would result in what, ultimately, for the requester?
That would result in the information, that would result in the arguments that are raised not being addressed to the information for which there are no arguments. And if there are no other arguments, then the information would be released.
Okay, so I want to make sure we all understand what your testimony has been here today. So we had the first request to TSSB in the fall of 2019. Was any information disclosed to Nate Paul as a result of OAG's ruling?
No.
Then we move on to the big request to DPS in the spring of 2020. Was any information released to Nate Paul as a result of that ruling?
No.
And then we get to this third request. And what we see is that the FBI provided a copy of the brief directly to the requester itself. Is that right?
That's right.
Objection leading.
Oh.
Overruled. Repeat the question and answer.
We get to this FBI request for their blacked out brief. And what we see is that the FBI directly gives a copy of the brief to the requester, to Nate Paul. Is that correct?
Objection, Your Honor. It should be made clear for the record that we are talking about two different briefs, one in May and one in June. And the one in June, yes, there's no dispute. The FBI provided that to Nate Paul's counsel. That is not the one that contains the sensitive information that we have been discussing.
Clarify.
Of course.
I sustain the objection. Clarify.
What we're seeing from this file is that the FBI provided a copy of its June 2020 brief directly to Mr. Larson. Is that right?
Yes, that's correct.
And you've also testified that that June 2020 brief is very similar to the May 2020 redacted brief, right?
Yes, that is correct.
And that ultimately, because the FBI did not address why their redacted brief should not be released to the public, it was released.
Objection leading.
Sustain. Rephrase your question.
What was the ultimate outcome of the opinion on this FBI request related to its redacted brief?
The opinion concluded that the unredacted brief could be released to the requester.
And you reviewed that brief?
Yes.
And you did not see any mandatory exceptions within that brief that would require OAG to apply its own redactions before release?
That's
Objection
correct.
leading.
Overruled.
That's correct.
And after this ruling in August of 2020 on the FBI brief, do you recall one way or another if Joe Larson, on behalf of Nate Paul, continued to seek information from public safety agencies through public information requests?
Yes, he did.
And how do you know that?
He continued to pursue complaints against the Texas State Securities Board all the way through September of that year, seeking to obtain documents that TSSB was withholding from him in the context of Public Information Act requests. So then that continued, throughout the summer and into the fall.
And after ORD rules on a request, what does ORD do with the documents that the governmental agency provided to you to make your ruling?
We send the documents back to the governmental body.
You don't keep a copy?
No.
Those are all my questions for this time. Thank you.
Thank you, Ms. Collins.
Examination, Your Honor.
Yes.
I'm so sorry. One thing, we are moving for admission of HM 46 and AG 34 based on this witness's testimony.
Your Honor, same objection. All we're trying to do is protect the sensitive law enforcement operations, who was involved, when emails were sent, what the subject of those emails were, what the FBI's operations plans were, how they work with the State Securities Board, the FBI, the DPS. If that information can be redacted, no objection.
Hold on. We've discussed this at length. He testified there was nothing confidential. The FBI could be here. They could be called.
Yes, Your Honor, or Mr. President, yes, that's correct.
Either one, doesn't matter.
Okay, yes, sir.
But they're not here.
They're not, however, I would like to, for the record, remind the court that it was Mr. Bangert's testimony opposite to Mr. Gordon's.
Your Honor, I'm going to insist that she not say testimony of another witness in front of this witness.
Okay. Both of you, just stop for a moment, okay?
Okay, so our mics are up. Deandra, go ahead.
Okay. I'm interested in what, it seems like they already had a little powwow on this exact objection, and now they're back talking about it. So I don't know what the issue is. I thought he'd already made a ruling on it.
And this seems to be more lawyers involved in this discussion besides Justice Myers. This looks like when they call all the referees in to look at the video replay to figure out what's going on.
Yeah, it was kind of.
Your Honor, if I could, I just want to make sure that there's no misunderstanding or misstatement here.
Jurors, please take your seats again.
I just want to make sure that there's no misunderstanding here, that you have a complete copy of those files in front of you, and you can see for yourself that there are no copies of search warrants, there are no copies of the actual emails within those files, which appear to be the documents that counsel is concerned about, and I just want to make sure that's clear for the record, that those documents are not in those files.
And we have reviewed them while up here going through this testimony. Is it your representation as an officer of the court that this document has already been released to the public?
Yes.
Both documents?
Yes.
And that was the testimony?
It was.
I have to overrule your objection. We'll admit into evidence AG 34 and OAG Exhibit 46.
That should be HM 46 and AG 34, Your Honor.
HM 46, yes.
Thank you, Your Honor. Those are my questions for now.
Yes. Your witness.
Good afternoon, morning, Mr. Gordon.
Please state your name for the record,
Leah Graham. You talked about this decision being fact specific. Do you recall that testimony?
Yes.
So let's talk facts. The requester in this case was Nate Paul's lawyer, correct?
Objection, speculation.
I believe that same testimony was elicited on direct that Joseph
overruled.
Larson.
Go ahead.
Correct.
We did not know that at the time. It's become apparent that that is the case now, but we did not know that at the time.
In your original opinion, as it relates to the request for the full release of the DPS file, was that it should not be released and that the law enforcement exception applied. True?
That's the big DPS file that we're referring to?
Yes, sir.
The original draft on that, I believe, did just address it under the law enforcement exception.
And that was your opinion that it should not be disclosed under the law enforcement exception, correct?
No, that was not my opinion. That was just the first draft that was on the ruling.
Who drafted the first draft?
I'm not sure if that was the drafter on the ruling or if that was me. I don't remember.
You had direct conversations with Ken Paxton about this specific request for a full copy of the DPS file, true?
Yes.
He made it clear to you that he wanted to find a way to release the documents that Nate Paul's attorney was requesting, true?
Objection, Your Honor. That's improper testimony through this counsel, assuming facts that have not been addressed with this witness.
Your Honor, this testimony has already been elicited.
Overruled.
True?
No.
Mr. Paxton did not summon you to his office to talk about this file?
Yes, he did.
He did not put pressure on you to either not rule against the requester or to release the information?
No, I would not classify it as pressure. The decision that we made was not.
Sir, I appreciate that. I'm not asking you what the decision was made. I was asking about your conversation with Mr. Paxton. He had one of two things that he wanted to occur. Either release the information or at a minimum, figure out a way not to rule against the requester. True?
Same objection, Your Honor, assuming facts not before this witness.
Sustained.
In your conversation with Ken Paxton about this particular DPS file, can you recall any other time when Mr. Paxton directly came to you and got involved on a DPS open records request?
No.
Ultimately, you did exactly what Mr. Paxton wanted, correct? You did not rule against the requester, Nate Paul's attorney, true?
Again, objection, Your Honor, assuming facts not before this witness.
Overruled.
True?
I'm sorry, could you repeat the question?
Yes, sir. Ultimately, the opinion was not to rule against the requester, which was exactly what Ken Paxton was pressuring you to do, correct?
Again, Your Honor, I'm going to object. She's now mischaracterizing this witness's testimony. He said he was not pressured.
Sustained.
By not ruling, you were not ruling against the requester. By making a no decision, that's not ruling against the requester, true?
That's correct. We didn't rule against either party, the requester or the governmental bodies at issue.
Now, earlier you said that the OAG decision not ruling against Nate Paul's attorney, quote, tilted the scale in terms of how a court would ultimately decide whether or not to rule on the disclosure of that information. True?
No, if I said that, I may have misspoken. We did not want to tilt the scale. We didn't want to tip the scale either way. We wanted to maintain the status quo and allow the court to review it completely de novo without our opinion, which is due great weight, tilting the scale based on the procedural requirements.
Withholding the information would have been detrimental to the requester. That's what you said on direct. Do you remember that?
I'm sorry, could you repeat the question?
You said withholding the requested information would have been detrimental to the requester. Do you recall that testimony?
I'm going to object, Your Honor. I don't recall that testimony either, so mischaracterization of his testimony.
And I'm happy to put her on the stand. I'm asking the witness if he recalls his testimony.
We can check with the court reporter.
I have a quote, it would have been detrimental to the requester.
Okay. I'm going to overrule. You can answer yes or no.
Yes, it would have concluded that the information could be withheld.
Now, on June 8th, after the opinion came out, Joanna Ward, do you know who that is?
John Award?
Yes, sir.
Yes.
Okay. On June 8th, she was asking if you still had the file in your possession. Do you recall that?
Yes.
And the file she was referring to was the entire DPS file, correct?
Yes.
And within that file is one part of it would have been the probable cause affidavit that Nate Paul was looking for, correct?
No. I believe that, if I'm not mistaken, I think that was after the ruling had been issued.
It is, sir, but that's not my question. Included within the DPS file would have been the probable cause affidavit that Nate Paul was looking for, true?
No.
The probable cause affidavit would not have been within the DPS file.
Not after we issued the ruling, we would have sent the documents back to DPS.
But by June 8th, after the decision was released, do you recall Joanna Ward emailing you and specifically asking you if you still had it, it was still checked out to you, and asking when you were going to return it? Do you recall that?
Yes.
We talked a lot about precedent and what should be publicly disclosed. You would agree with me that a search warrant is treated substantially differently than a probable cause affidavit or search warrant affidavit in terms of whether or not that should be released to the public, correct?
There are different exceptions that can apply to those, but I would not characterize anything as what can or should be released to the public. It needs to have an exception that applies to it. But both can be released to the public. A search warrant affidavit is more likely to have an exception that applies. They're not automatically confidential.
Correct. No further questions, Your Honor.
Redirect.
Very briefly, in any of these requests, could either party have filed a lawsuit challenging the outcome?
Yes.
Did anyone file a lawsuit for the outcome of the FBI brief ruling request?
No.
That's all I have, Your Honor.
And just so the court knows, because it has been unusual, either side can ask questions from the podium or their tables in case anyone's asking. Can the witness?
Requires no redirect, Your Honor.
Pardon?
Witness requires no redirect. Recross.
Can the witness be excused?
Yes, Your Honor. Thank you, Mr. Gordon.
Am I released, Mr. President?
I'm checking with the House. Yes, you can be released. Thank you.